Good morning, everyone. We're going to get started probably in about 1 more minute, right on time, because we do have a lot of topics to cover during the course of today. Good morning. For those of you who don't know me and we haven't had the chance to meet yet, I'm Tawny Alvarez. I'm a partner in Verrill's Labor and Employment Practice Group. I want to welcome you to Verrill's first ever virtual annual update. I know that a year ago, Rob and I were not expecting to be hosting you all from the comfort of our home offices, but we have made this decision to ensure that everyone stays as safe and healthy as possible. Additionally, because we know sitting on Zoom all day can be exhausting, we've taken our traditional day-long programming event and we've broken it up into hour-long sessions on the third Thursday of each month. Each session will cover a different topic relevant for employers. Before we get started, however, just a few housekeeping items. First, your lines have all been muted to avoid interference. Please submit any questions you may have through the Q&A feature on your screen. We'll do our best to answer those questions throughout the program and as time allows at the end. As we have also dropped a link in the chat function, or we will be dropping a link shortly, which will bring you to a page in which you can download the slide deck that we will be using today, as well as certificates of attendance for Maine CLE and SHRM credits. This morning's session is for the Maine update, but we welcome you to stay on throughout the day for the Massachusetts update at 11 a.m. and the Connecticut update at 1 p.m. If you're joining us for one or both of those additional sessions, please note that the Zoom link is the same for all three. So you don't need to sign out and sign back in, but if you'd like to, you can sign out and you're going to hop back in using the same link that you had the first time. Lastly, the next session for our annual update series is going to take place on February 18th, and it's going to cover joint employers and independent contractors. And with that, we're going to get started, and I'm going to turn it over to Rob.
Thanks, Tawny, and thanks to everybody for participating in today's webinar. It's a huge change for us, as Tawny was saying, and in some respects, it is a disappointment for us because this event is one that we always look forward to as an opportunity to see all of you in person and to get caught up, and then maybe have some food together at lunch, and then maybe some drinks afterward at the reception. So I regret that we can't do that this year, but we can hope that next year we'll be returning to that more interactive process. So meantime, however, thanks for participating today, and we do have a lot to cover. This particular session today is an attempt to replicate what is usually our first session of our annual update, which we've been doing for, gosh, I think over 20 years now, 25 years. And the first session typically is a grab bag of topics that we haven't otherwise covered or won't otherwise cover in more detail later in the day. And so here we'll be talking about in the next hour a variety of topics, including independent contractor updates, Supreme Court cases, legislative updates, Maine and federally, some Maine non-competition law. For those of you in Portland, there's an update on the minimum wage ordinance. And the first topic, however, is one that is pretty timely. It's about vaccine mandates. And so this is one that is what I think we'll cover in a little more detail, probably the first 15 minutes or so. And in some respects, this perhaps could be a topic in and of itself for a full discussion, but this topic is so timely, and we're being bombarded with questions from clients constantly about the COVID vaccines and whether they should be mandated, how should we handle them. who should pay for them, those sorts of things. This is not something we've discussed in detail at our prior seminars before, and it's not typically a topic that HR professionals have to deal with. And so that's, I think, where we will start today. Next slide. So in terms of, so the next slide. Thanks. So what's going on with the these vaccine mandates? The current landscape that we're in is, it's incredibly stressful for a lot of people. As I think everybody would admit, there is just a lot of fear, tension, anxiety, anger, you name it, in the environment. And so we are, I think it's fair to say that a lot of people in this country are sort of on 11, if I can quote from one of my favorite movies, Spinal Tap. This is a really explosive environment that we're in. And so, nothing seems to provoke more interest and attention and anxiety and passion than vaccines, and also masks seem to be up there as well. We're not going to talk about masks today, but vaccines are one that is really, really topical and controversial, apparently. And so, why is this so controversial? I think this is a setup of a conflict between public health goals and individual freedoms to decide what medical procedures you're going to do for yourself, for your own body. Interestingly, there's some pretty significant pockets of resistance to the COVID vaccines, mandated or not, but some resistance to the vaccines in a lot of sectors, even among healthcare workers. There's a recent story out of California that about 40% of the healthcare workers and certain healthcare providers were declining to get the vaccine. Per the Wall Street Journal earlier this week, the survey of New York residents suggested that 27% of the residents of New York were not going to get the vaccine. Similarly, I think the AP reported just yesterday that about 26% of the US population was not going to get a vaccine. And so that's a big percentage of the population, and it seems to run counter to the messaging from public health authorities that to reach herd immunity, to control this pandemic, we need 75, 80, 90% of the population to get vaccinated. So we have a pretty clear tension emerging between a good percentage of the population and public health authorities. And so how that tension gets relieved remains to be seen. There are some other issues and concerns about side effects that seem to be supporting this perception by some that they don't want to get the vaccine. I think it's a little more than just they're against vaccines. There seem to be a fair number of people, especially healthcare, articulating objections based on side effects. Just to name a few that are just showing up in the media, you had, within the CDC reported that within the first week of the Pfizer vaccine being rolled out in the U.S., they recorded about 5,000 adverse reactions, most of which are probably very mild, but they still recorded more than 5,000 reactions in the first week. Those included severe allergic reactions from healthcare workers in Alaska, one who was in intensive care for 2 days. Just last week, the New York Times reported that an obstetrician in Florida died following the receipt of the Pfizer vaccine because of an autoimmune disease that has attacked his platelets. And so, according to this expert quoted in the New York Times article from Johns Hopkins, it was almost a certainty that the vaccine led to this doctor's death. And just this week, the state of California issued an order, or at least a recommendation, that there be a pause, or basically an order not to use a particular lot of Moderna's vaccine, about 330,000 doses of it, that were observed to have caused, or at least associated with, severe allergic reactions among a bunch of healthcare workers in San Diego who were getting vaccinated, and then they had severe reactions within the 15-minute observation period. So the numbers are a little sketchy. Seems to be more than 6, less than 10, based on the news reports that I saw. So that's this week. So this is all emerging very rapidly. So I think these media reports are perhaps one reason why there is appears to be, based on some polls, a resistance to the COVID vaccine. So next slide. So what's the current landscape? And federally, there's no mandate at the federal level, at least not yet, for any vaccine. And that's because when it comes to public health and safety under the US Constitution, those sorts of powers for public health and safety are left to the state for the most part. They're called the police powers of the state. And so the federal government essentially has been busy just issuing recommendations from the CDC and NIH and FDA, but primarily the CDC. So what are the states doing? Well, the states, again, as I mentioned, have the authority to look out for the health and safety of their citizens. And they've got pretty broad authority to mandate vaccines. And the authority for this is based largely on a US Supreme Court decision from 1905. So it's pretty old, called Jacobson versus Massachusetts. And that was a decision that arose from a mandate from the city of Cambridge to order vaccination for smallpox of its citizens. And this Swedish immigrant named Jacobson didn't want it, and he didn't want to pay it was a $5 fine for refusing the vaccine. And so he took his case all the way to the US Supreme Court, and the Supreme Court agreed with the Commonwealth of Massachusetts that the mandate for the smallpox vaccine was lawful, but they did note that it could reach there are circumstances like medical reasons why it would be an overreach to mandate a vaccine. So that Jacobson case has been around for a long time, and it's being cited just everywhere by health authorities, by courts, as the basis for supporting state and local mandates for vaccines, and the COVID vaccine in particular. So it's interesting in that I'm not so confident that decision is necessarily going to be as influential going forward. About a month ago, the Supreme Court struck down some COVID-related mandates in the state of New York for public gatherings, including at church services. And the Supreme Court said that the Jacobson case doesn't extend that far. And Justice Gorsuch actually wrote a concurring opinion where he implies that Jacobson doesn't give states as much power as they think they have to limit constitutionally protected freedoms. So that's a case that will be under scrutiny. And actually, there's a decision out of Maine earlier this year concerning the governor's orders about quarantines and lockdowns, and the federal judge, Judge Walker, analyzed Jacobson, and he basically followed it, but he did note that it's an old case and it may not be consistent with current understandings of individual liberties recognized by the more recent decisions of the US Supreme Court. Anyway, very interesting. Bills are pending in a lot of states, 9 so far, that would actually prohibit discrimination because of vaccinated status. And that's not just for employees, so it would be for customers too. So you can't turn someone away for not having a vaccine, at least according to these bills that are in 9 states. Conversely, New York has got a bill that would actually mandate the COVID vaccine on citizens if vaccination rates don't get high enough to reach herd immunity. So it's a real grab bag of legislation or bills that are pending. And so we just have to wait and see what happens. Next slide, please. And in Maine, so what's happening in Maine? Right now, there's no vaccine mandate, no COVID vaccine mandate for the general public. And we couldn't find any bills pending either. So that's, at least for now. Again, at any time the legislature could pop in a bill, and that could be under consideration. But what is under consideration right now is something that affects pretty much every healthcare employer in the state of Maine, This is a bill, or rather a rule, that DHHS announced in the fall. They had hearings in November, and there's an existing bill that requires, or rather existing rule in Maine that requires vaccination, essentially common diseases, mumps, measles, rubella, hepatitis, more common diseases, for designated healthcare facilities. So these are nursing facilities, residential care facilities, intermediate care facilities, facilities that care for individuals with intellectual disabilities, hospitals, home health agencies. So this rule has been in existence for a while, but it doesn't include a mandatory COVID shot, naturally, because it didn't exist yet. And it didn't include a mandatory flu shot either. And there were exemptions for medical reasons, religious reasons, and even philosophical reasons. If this person just said, I don't want it, they could turn it down. This proposed rule, and again, they had hearings on it just about 2 months ago, would add a mandatory flu vaccine to the list for seasonal influenza. It would also add any vaccine that's imposed by the Maine DHHS, basically CDC, in the event of a public health emergency. So it doesn't explicitly say a COVID vaccine or a novel pandemic type vaccine, but it's clearly a basis for the Department of Health and Human Services to essentially say at any point within its discretion, you know what, we're going to add a COVID vaccine here because we have a public health emergency declared by the governor. This rule gives us the authority to do it. And so this is in the works and would apply to all the healthcare facilities that I'd listed, but it also could be a model for other industries too. So it could be schools, could be hospitality. So this is a rule to follow for any employer in the state, especially healthcare employers. Another significant aspect of this proposed rule is it eliminates the philosophical exemption. So you'd have to have either a medical or religious basis for refusing these vaccines. And by eliminating the philosophical exemption, the rule potentially puts employers in a box, because now employees can't just say, I'm exercising my philosophical right to say I don't want it. Now you kind of have a fight with any employee and the employer who asserts a religious or medical exemption, potentially. And there's no easy way to avoid it. So you kind of have an interesting conflict between state regulation and federally protected rights. So who wins on that? It depends. It depends on the situation. So stay tuned for that. Next slide.
I think that based off of everything Rob said to this point, it's clear to most of our participants that we find ourselves in a place in which everything is novel. We don't have laws that have been set up to deal with COVID. Everything has been reactionary. And even when we're looking back at old laws, 1905 Supreme Court rulings, none of them are directly on point with what we as a country have experienced over the course of the last 11 months. So keeping that in mind as we move forward is really important.
Yeah, that's a great comment. And, I'll try not to use the word, interesting legal issues too much today, but whenever you hear a lawyer say that's a really interesting legal question, it means we don't know the answer or we're not confident in the answer. And if you want to push that question, then you may be the next test case, which would be very interesting and good for the lawyers, but maybe it's not a position that you as the employer want to be in. So what's, I guess, the big question that we're getting a lot is, and we're seeing in the media, it's all over the place, is can employers mandate employees receive a vaccine? When we just talked a minute ago about can the government do it? Probably yes, maybe. But can employers do it? And the answer is yes, maybe. So I wish we could be more confident here, but just to set up the question before we get into the analysis of it, I just read this week a survey of CEOs, and according to the survey, 70% of chief executive officers want to mandate the COVID vaccine, which surprised me. I thought it was higher than I expected, but assuming that survey is reliable, that's a big number. And so I think to the extent that anybody on this call is being approached by their CEO and hey, let's mandate the vaccine. I think you should pay attention to at least understand the risks that we're going to talk about here and the uncertainties. So why do we think that employers can mandate employees receive a vaccine? Well, a couple reasons. First, we'll talk about this more later, but most employees are employed at will. So employers have the right to hire and fire for any reason or no reason, as long as it's not an illegal reason. So the EEOC just weighed in a couple of weeks ago on this question, and they said that the risk area for employers mandating vaccines is typically an ADA issue. Employers are not supposed to make medical related inquiries or do medical exams without a business reason. And so to the extent that is vaccination a medical exam or a medical inquiry? Well, the EEOC expressed an opinion. Again, these aren't binding on the courts, but it's their opinion that a vaccination is not a medical exam under the ADA, and so therefore it's not prohibited by the ADA. And so the next question they answered was, well, it's because whenever you administer a vaccine, it's essentially a medical procedure. It's immunotherapy. That is being done. It's designed to change someone's immune system. So that's one way to look at it. I think it's helpful. And so before you do a medical procedure on somebody, you have to get informed consent. So you got to ask some questions if you're the person giving the shot. And so the EEO said, well, you're starting to ask questions about that. Well, now you're getting into ADA territory. You have a reason for doing it? And so the EEOC said, well, if you don't ask the questions, then you're not really pregnant with the knowledge of their medical condition. And so if you outsource it, and they said if you can mandate, we think employers can mandate the COVID vaccine without violating the ADA if they sort of outsource the providing of the vaccines to a third party, like a pharmacy, or you basically just say to the employee, just show us proof that you got the vaccine. We don't care where you get it or how you get it, just show us proof. So if you take that approach, then you're not asking the questions. And then if somebody comes back and says, hey, I have a medical condition, I need some accommodations, then you have to go through that interactive process, whether it's for a disability or even under religious reasons, which we'll touch on later. And so, this is, again, the EEOC's opinion rests on this assumption the employer doesn't do a disability-related screening inquiry before they get the answer to the question of whether the employee's got the vaccination or not. Next slide.
Bringing this and Rob's statement to Maine generally, however, everyone should recall that under Maine law, if a medical examination does occur, employers are going to have financial obligations related to that. While the Maine Human Rights Commission has not specifically made a statement concerning COVID vaccines, we know in the past that they usually fall in line with what the EEOC has said or indicated. So that finding that it's not a medical examination further has implications on Maine generally as well.
Yeah. Right. And so, in turning to this analysis of whether an employer can mandate the COVID vaccine, we first talked about the outsourcing. The EEOC said if you outsource it, you're okay, most likely. But if you're doing it yourself, let's say you're a healthcare provider, you're a hospital, and you're actually administering the shot, then they're saying, well, hey, now you're making inquiries about this person's disability status, and if you're going to do that, then you have to be able to show that your inquiries are job related and consistent with business necessity. So what's that mean? Well, the EEOC has said that, well, that analysis, whether something's job related and consistent with business necessity, it needs to be based on objective evidence, and more specifically, objective evidence that shows that the employee, if they don't have the vaccine, will pose a direct threat to the health or safety of him or herself or others, like coworkers or customers. And so that's that analysis is important here. because it basically says if you're going to mandate vaccines, you should be ready to have objective evidence to show that this person poses a direct threat to themselves or others if they're unvaccinated, which may pose some problems because with the EEOC's analysis, which I think a lot of employers have seized on that, and they said, "Hey, great, the EEOC says we can mandate vaccines, great," and they didn't read the rest of the guidance. One thing that the EEOC said was, "Hey, this is a moving, this is not a static situation, and everything needs to be looked at based on the facts of the situation at the time that of the mandate, when the issue comes up." So this is evolving, and so I think as a practical matter, even if the employer outsources the vaccine to the pharmacy, just we don't care how you get it, just bring us proof. When the employee comes back with well, let's say the employee has no proof and says, "I didn't get it," the next question from the employer is, "Well, why not?" The employee says, "Well, because I have an allergic reaction to others, like to peanuts, and I've read about all these people who have had bad reactions to the vaccine who have food allergy. So I don't think it's safe for me, and my doctor agrees with me." So, so now the employer has to essentially, no matter whether they do it themselves or they outsource it for the vaccine, then they're probably going to be in a situation when they have to show a legitimate job-related necessity, and that there's objective evidence to support this mandate. So, next slide. So what evidence is there that an unvaccinated employee is a direct threat to others? The EEOC actually said in their guidance that, hey, we think an unvaccinated worker could be a direct threat. But they also said, you got to look at the situation too. So it was sort of an equivocal statement. So what's the objective evidence that an unvaccinated person is a direct threat to others? Well, what we're talking about essentially is transmission. Is that unvaccinated person going to transmit the disease, COVID? And it's worth noting that at least today, the emergency use authorizations for the Moderna and Pfizer vaccines, they were granted on the showing that the vaccines reduced symptoms, moderate to severe COVID symptoms. And if you read the actual approval, this FDA says this, the CDC says this, Dr. Fauci says this, the manufacturers all say this. They don't have any data that currently exists that either of these vaccines that have been approved reduce transmission. So if there's no data that shows that the currently approved vaccines reduce transmission, how is an employer going to show that an unvaccinated person poses a greater risk of transmission than a vaccinated person? I think they're going to have a hard time, at least until more data comes in. It's worth noting that these emergency use authorizations are granted after only 2 months, and these trials are set to go for 2 years. So they'll be presumably looking for this data, and it may turn out, I think everybody hopes it will, turn out that these vaccines reduce transmission. But right now, that data doesn't exist, according to the FDA, the CDC, and other authorities. Next. So, let's say you have an employee who doesn't have a disability, who says, or a religious issue, says, "I'm just not getting it. I don't think they're right. I don't think you should make me." And I think there's a lot of people out there right now who would take that position based on the surveys that we're reading about in the news. And so, is there, hey, employee at will, you don't want to work here, there's the door. Can you safely and without risk take that approach? Answer is, I don't know, maybe. It's an interesting question. There's a public policy exception that exists to the employment at will doctrine in most states. It's not used very often. Maine, in theory, has it, but it's rarely used. But basically, the principle is an employer can't terminate an employee if it would violate some important public policy issue at the state level or the federal level. And so, I think it's worth noting that the current vaccines were approved under the emergency use authorization, which allows for the use of what they call unapproved medical products in certain emergencies. So I think it's useful to look at the Moderna and Pfizer vaccines and maybe the Johnson & Johnson vaccine that's up next, or AstraZeneca. they get an EUA, these are just for unapproved medical products. They aren't licensed yet, and they can't get licensed until the whole thing is done, the study, which is maybe a year from now or 2 years. So the FDA regulations state that recipients of anything approved or authorized, I should say, under an EUA have to be given the option to refuse the vaccine. And so, does that which sets up this conflict between a federal right to refuse an experimental medical product or an unapproved medical product versus an employer's right to terminate at will. And so which right will prevail? We don't know the answer to that yet, but this is the kind of fact pattern that does lend itself to an exception to the employment at will doctrine. So again, we don't have any cases on this yet, but I think it does elevate the risk assessment for an employer who wants to terminate somebody because they refuse to get a COVID vaccine. Next slide. I think Tawny's going to take over here because there's a bunch of other issues too.
So in addition to just the general science and a discussion as to where we find ourselves right now from a health perspective, there's other aspects we need to keep in mind. And one of it is that our employees can request a religious exemption. And a religious exemption would extend not just to employees who are members of organized religions, but also to individuals who have sincerely held religious, ethical, or moral beliefs. So this wouldn't be a situation where we look and say, well, the Pope or some other religious authority has said, it's okay, I think you should have the vaccine. The person still has a right to take their own approach on the issue, and you wouldn't be in a position as an organization to dictate their actions or otherwise terminate them for refusal based off of Title VII and the Maine Human Rights Act, religious anti-discrimination provisions. In addition to the religious exemptions, other things to be considering would be aspects regarding unionization in the National Labor Relations Act. So if you already have a unionized workforce, employer vaccination mandates would be a mandatory subject of bargaining. I would presume that most current contracts don't include those type of provisions, so you'd have to wait until your next bargaining session. Additionally, when you consider rolling out a program in which you're mandating or requiring certain action, in those situations, oftentimes we'll see a negative impact on morale in which employees feel as though some of their rights generally are being infringed upon. We see it a lot when employees are saying, I have the freedom of speech, not understanding that that's against the government as opposed to a private employer. But you risk you face a risk that your employees will seek to begin collective action and discussions of the terms and conditions of employment, which would be protected under the National Labor Relations Act. So that would be something to keep in mind as you are considering whether to mandate mandatory vaccines and then how you roll that out. Additionally, you're likely going to be seeing issues regarding OSHA retaliation. Currently, OSHA has not created specific mandates. They've provided recommendations on proposed courses of action generally related to COVID. We suspect that under the change in administration that Biden's OSHA will have very specific requirements as to what employers must do. But if you have employees who are making complaints regarding workplace health and safety, specifically saying that they don't believe the COVID vaccine is safe, that they're pointing to injuries or other issues, you could then be dealing with an OSHA retaliation issue. And finally, some workers' comp claims potentially for vaccine injuries. So right now, as Rob had pointed out earlier, we've seen 5,000 at least adverse reactions that have been reported to the CDC. And that was only in the first 5 days of the Pfizer vaccine rollout. So some workers' compensation carriers are likely going to say offer it on a voluntary basis as opposed to mandating it. We got a question which was, could the direct threat be a consideration for a workers' comp claim? One of the aspects that we're paying very close attention to is workers' compensation presumptions, and the idea or concept that if you tested positive for COVID-19, is there a presumption that you obtained the virus from work? And Maine has not set forth any proposed legislation to create any form of a presumption. Many states have created presumptions. Some have gone so far as to say anyone who's working with the public would be presumed to have contracted COVID-19 at work. Others have simply limited it to first responders and things to those natures. So those are things to keep at top of mind in addition to the general health kind of discussion about mandating vaccine. These are some of the additional things to keep at top of mind.
Yeah, one other issue, Tawny, I think, yeah, on the workers' comp issue, that's typically an occupational disease, which this might be, if somebody got COVID at work or an employee gets COVID and they think it's because of work, that's usually a very fact-intensive process to resolve the claim. That would very likely go to a hearing, and you'd have experts and you'd have lots of factual testimony coming in about, I never left my house except to walk to work. I never saw anybody, except people at work. And then I got sick and I got COVID. Okay, so that's the case. That's pretty good, for causation. But, well, did you go to the grocery store? Yeah, I went to the grocery store in the, 2 weeks before I got sick. All right. Well, how do you know you didn't get it at the grocery store? So causation can be pretty hard on these. And I think there's going to be an incentive for most workers' comp carriers to defend those sorts of claims pretty aggressively, because the cost can be very high. If somebody gets sick with COVID, they spend 2 weeks in the ICU, you're looking at a $500,000 exposure. And I think most workers' comp carriers would say that we didn't charge a premium to ensure the risk of COVID. They may have an ability to retroactively adjust the premium depending on the claims that are filed, but still, I think there'll be an institutional resistance to coverage by comp carriers. Another question about liability for COVID and or vaccine injuries. There's a bunch of cases now pending by employees who say their employer didn't do enough to protect them from getting COVID. And so the employers are actually saying, hey, this is the workers' comp claim. You can't sue us for tort damages in court, which would have no cap, mind you, on damages. You're limited by the workers' comp remedy of the state that you're in. And these claims are trying to get around that workers' comp bar, and those cases are still just in their infancy. And of course, the corollary is, let's say there's a vaccine injury. Will the employee try to get around that if there's a mandate or even an implied mandate? Let's say you make it voluntary. And if it's a voluntary request for employees to get the vaccine, your risk goes way down. Whether it's for workers' comp or any tort liability, hey, it's up to the employee. It's their free will. Actually, and some employers are actually just giving incentives. They're offering bonuses. I just read in the newspaper yesterday that there's a marijuana dispensary in Oregon that's offering free joints to their employees who get the vaccine. The employers are getting quite creative. So the question of liability is kind of interesting in that, let's say you have a vaccine injury, somebody gets really hurt, has a bad reaction, they're in intensive care or whatever, or worse, they die. But who's liable? If it's not covered by workers' comp, about the only entity left that's standing that's potentially liable is the employer. Because it's worth noting that there's no liability for the manufacturers and the medical providers who are administering the vaccine under the PrEP Act. So it's essentially the employer is the only one standing. So it's worth keeping that in mind, that you're not going to have much company in the defense side if there's a really bad outcome from a vaccine. So,
one of the questions we just received, Rob, was since this is brand new for HR professionals, is there guidance on having conversations with employees to gauge or get a sense as to their personal views on receiving the vaccine, whether on a one-on-one or in a survey format?
boy, good question. I don't think there's any guidance that I'm aware of on. I have conversations with employees about their personal views on vaccines. You might elicit somebody's medical status, so there's a bit of a risk there that you're going to get information that maybe you don't want to hear. Although you're more likely to get sort of a political or personal view. But surveys, probably not a bad idea. If you're thinking about mandating a vaccine, you might get a survey might give you a sense as to how much pushback you're going to get. And if you get very little pushback, then maybe the risk is lower, and you go ahead and do it.
And another thing to keep in mind kind of generally is that when you're doing something like that, follow-up questions are not going to be something you're going to want to include. So it's not going to be, will you get the vaccine, why or why not? Because if you're then going to obtain potentially health or religious information that you don't want. So I'd make sure that you and your senior management team have had discussions about what way you're leaning or what you're considering prior to going out and speaking to employees.
Yeah.
Another questions come in regarding national employers that have been reported as willing to pay their employees to get the vaccine itself, and whether there's risks or liabilities for this type of incentive, for lack of a better word. I think a better way to go about doing something like this, and Rob, you can correct me if I'm wrong, is for paid time off. We've seen employers who are offering leave in order to obtain the vaccine, which in many ways is going to be like pay. They could cash out that paid time off if they don't need to leave work in order to take it. They could use that PTO at another time. Using it in that format, I think it is better. When we're talking about the incentive itself, whether it increases the risk of liability, potentially. I mean, we're in this new space and realm. It could tie it under the workers' comp aspect. They paid me to do this, so of course I did it, or I felt as though I was being forced to do it as a result of receiving the pay. It's going to become a very fact-specific analysis under the workers' comp to see whether or not it would fall within it. Also, if you're paying them to have it, if it's off-site that they're getting the shot, when they're driving, is it work time, kind of some of those bigger questions. I prefer, from a risk standpoint, providing the extra PTO to employees. Rob, anything to add to that?
Yeah, it's a great question. Yeah, we've got a bunch of questions now about employers paying for this and the risks. And I mean, I think to the extent that for work time, if an employer is mandating that somebody get the vaccine as a condition of employment, and if they do it during work, then that's arguably work time. But if you just say, hey, just show me proof that you got the shot, then and even if you give them a bonus for getting the shot, hopefully we're not encouraging the marijuana cigarettes as a bonus, but a little extra payment, a gift certificate, something like that. Then that's the liability. I think the risk goes down for a wage and hour claim. And I don't perceive any significant liability to the employer by paying for the vaccine or paying a little extra money or benefits either. I think, that's sort of in the realm of a discretionary payment that incentivizes employees to do good things. Sort of akin to a wellness bump, which are generally permitted. Really good question about, is there liability to the employer if the employer does not mandate the vaccine, and you have let's say you're healthcare and you have a patient or resident who gets COVID and dies. Yeah, there's always potential liability there, whether the patient dies of COVID or flu. It could be some other communicable disease that your employee has that is transmitted to the the resident, but presumably you'll have insurance for that kind of third-party claim. So there's potential liability. So then the question is, what's the standard of care? Was the standard of care that, make sure your whole staff gets vaccinated for COVID? And that's an unanswered question. With the point I made earlier about transmission, there's no data yet that shows that vaccines actually stop transmission, which is why Fauci and the CDC and the FDA say, hey, you got to keep wearing masks even after you get the vaccine. So if you're still doing your screening for, health screens every day, do you have a temperature? No. Do you have any, symptoms of COVID? If the answer to that is all no, and you're making people wear masks and wash their hands and social distance, then you're probably going to be in line with the standard of care. But again, go ahead.
Sorry. Nope. Keep going, Rob.
That's it. I was pretty much done with that question.
Okay. From a wage and hour perspective, the question is, should we pay individuals if you're having vaccines on site? Should we pay for the time that they stood in line before they actually got it? Our answer is yes. We've had discussions with Beth Smith, who most of you know, and it's her view that Maine Workers' Compensation Board would likely find it work-related and falling within kind of the workers' comp realm. So you're not increasing your workers' comp liability. And because, especially with healthcare industry, you want your employees to have it for work-related reasons. I think it can be tied from a wage and hour perspective to work because it's being provided at work. I think that all those factors further support that you should be compensated for the time that you're waiting in line for it and that half hour after when you're viewing whether or not there has been any adverse reactions. Some questions: can we put in place certain allowances for employees that have the vaccine versus those who haven't, for example, traveling? You could, but the problem I think becomes what Rob mentioned earlier, which is that it still remains unclear whether or not somebody who's traveling can still spread the disease. So I think there becomes factual kind of health related reasons that we would say, so what's the difference between someone traveling who has a vaccine and who doesn't have the vaccine, and both are wearing masks and appropriately social distancing and kind of taking those other precautions that have been recommended.
And only come to work when they're healthy. You still have in place your pre-screening before anybody shows up to work.
The next question, and this is going to be our last COVID question, so we can get to the other. Oh, there's two good ones. Shoot, we're going to do two questions, and then so if we don't mandate the incentive, but if we don't mandate a vaccine, Rob, but we incentivize people or encourage them to vaccinate, would we need to make the incentive available to people who claim a religious or medical exemption?
That's a really interesting question.
And this goes into a benefits realm, which is, outside of Rob and my practice. But if I recall correctly, the answer is yes, that you would have to. Please, we're going to double check with the benefits team. But if I recall correctly, when we were discussing this for flu vaccines, their answer was that yes, we needed to make it available to people who aren't able to be vaccinated as a result of religious or medical reasons.
Yeah, I mean, it's unlikely if you don't make it available. I mean, I think it's unlikely to lead to litigation. I mean, I'm assuming that the incentives are not going to be so big that it's going to be so exciting that people are going to sue over it. But I think the technical answer is probably correct.
And then if you were to incentivize getting the vaccine, do you then need to worry about claims of retaliation later? Because would you then be keeping records that the incentive was given to an employee with the concern that employees who did not receive the incentive then were unvaccinated and are being treated differently by the organization? So Rob, would you foresee that we could have issues regarding retaliation as a result of an employee's choice to not be vaccinated?
Certainly if they turn it down for religious or medical reasons, but if it's just a personal choice, then I'd say no. But the second part of that question was really interesting, and you just zipped it off the screen, Tawny. Where did that go? It was.
sorry, in the answered question, they're an answer.
Yeah,
Yeah.
if you keep records of who's vaccinated, do you have to keep them confidential in HR, or can managers know? Well, I think, I mean, I think the answer, I think, is you should keep it confidential. I mean, I'll put the question this way. Is a person's vaccination status something that you typically file in a medical record? Yes. And if you typically find this sort of information in a confidential medical record, then I think you have an obligation to maintain its confidentiality. You know, so can managers know? I think if there's a legitimate business need, sure. But I would be very careful about getting out there or having people talk about someone's vaccination status, saying, "Oh, they're not vaccinated, I can't get near them." You know, you have the shunning issue, and you know, if there's a medical or religious reason for that, you know, that could spill over to the situation. Now you've got another type of discrimination claim.
Okay, we're going to go to the next slide.
Yeah, sorry.
Okay, so we have 10 minutes and we got 4 slides to run through with non-COVID related things that have happened in 2020 and what we're forward looking for 2021. You might have seen that earlier this month, Trump's administration proposed rule concerning independent contractors was finalized. Interestingly enough, you didn't get an email from the Taking Care of HR Business blog explaining why. The reason that you didn't receive any update on that is because we already had knowledge that the Biden administration was planning to revoke the proposed rule and the final rule regarding independent contractors. So what the Trump administration had attempted to do was make the independent contractor rules less strict so that more independent contractors could be designated, so that instead of having everyone as employees, you could use independent contractors more. And they were changing it to what's called the economic reality test, which means that you're going to look at only 2 core factors: the degree of control over the individual's work and the opportunity for profit or loss based off of investment in tools and those type of things. This rule will not be maintained. And what we're going to see from the Biden administration is something called the ABC test. The ABC test is what's used in California, in Massachusetts, in Connecticut, and a host of states. Interestingly enough, you see the little asterisk here. We note that state law may call for a more stringent standard. And in Maine, in fact, there is a more stringent standard than the ABC test. Those of you who have been in HR for an extended period of time will recall that in January of 2013, Maine Department of Labor updated its rules regarding independent contractor, creating a 7-step analysis to determine whether or not someone could be classified as an independent contractor, and really pushing people to classify everyone as employees and limiting the use of the independent contractor status. Okay, we're going to go to the next slide and we're going to talk about the Supreme Court and a quick update on that. And I'm going to turn to Rob first to talk about the first case, and then I'll clean up.
So this is the Bostock versus Clayton County, Georgia case, which was decided by the Supreme Court in June. And it's a landmark case for gay and transgender rights. Essentially, the Supreme Court finally recognized that being gay or transgender is protected under Title VII of the Civil Rights Act, because any action based on that status really is based on sex. And Justice Gorsuch, who wrote the opinion, acknowledged that. It was a 6-3 opinion, so there are 3 dissenters, but Gorsuch wrote the majority, and he basically acknowledged that that's the case. And this may seem like old news to you, but there has been a split among the federal courts and the state courts around the country, including and also the EEOC, that had recognized gay and transgender rights as being protected under Title VII. And so this now unifies the case law on this. It does raise some interesting issues, however, and I won't go into them in great detail, but if you're a religious organization, this may present some problems for you in terms of if you want to maintain your historic different treatment of people who are gay or transgender. There are some additional protections that the Supreme Court has recognized for the ministerial exception. So that's some protection there. Housing, let's say you're a university and you decide to room a transgender female with another female resident. Will that cause a problem? Or how about a transgender female with a male resident? Will there be any discrimination issues there under Title IX? Not sure. Yet to be worked out. Healthcare, will Title VII now prohibit a healthcare provider from denying coverage for sex reassignment surgeries? We don't know yet. Maybe. That may be one of the impacts of this particular case. So these things are still playing out, but again, this Bostock decision now does remove a lot of uncertainty, or the remaining uncertainty, I should say, as terms of the status of people who are gay and transgender under Title VII.
I'm going to jump to the two remaining cases that are noteworthy. And in both of these, we don't have a decision yet. Henry Schein versus Archer and White Sales, Inc. was argued before the court on December 8th of 2020. It's an appeal from the Fifth Circuit. And the issue before the court is whether a provision in an arbitration agreement that exempts certain claims from arbitration, whether that negates or changes the question of arbitrability of the claims for an arbitrator. So that is sounds like a huge legal mumbo jumbo. Interestingly enough, Henry Schein had been before the court already, before the Supreme Court. This is its second time before the Supreme Court with this case. Specifically, though, why it's important is because it's going to have far-reaching implications on employers' arbitration agreements and whether or not the court or an arbitrator is going to get to decide on what aspects of a matter are arbitrable. And then the last case is Van Buren versus United States. And this was argued before the court on October 30th of 2020, and it's an appeal from the 11th Circuit. The issue before the court is whether a person who is authorized to access information on a computer for certain purposes violates Section 1030 A2 of the Computer Fraud and Abuse Act if he accesses the same information for an improper purpose. So for employers who currently use confidentiality agreements, non-solicitations, or other agreements to protect information and access to information, if you've ever considered litigating as a result of a former employee leaving and taking with them confidential or proprietary information, you've likely had discussions with counsel regarding potential claims under the Computer Fraud and Abuse Act. And this case will help employers to have a better understanding as to the breadth of the use of that statute for employment-related matters. We have 3 more minutes. We're going to go to the next slide. Maine's earned paid leave law. For those of you, everyone who has Maine employees who has more than 10 employees within the state, they know that Maine's earned paid leave law went into effect on January 1st of 2021. It requires that employees are permitted to accrue 1 hour of earned paid leave for every 40 hours worked. And this is for all employees, per diem, temporary, seasonal. There is an exemption from a seasonal nature if you are a seasonal business, but if you are a non-seasonal business and just have seasonal employees, those employees are still going to be entitled to earn that earned paid leave. Additionally, employees must be permitted to carry over at least 40 hours of leave from one defined year to the next. One of the questions that we have is if the employee has been employed more than 120 days prior to 1/1/21, are they eligible to use accrued hours as soon as they have worked 40 hours in 2021? Once they've worked 40 hours in 2021, then they arguably would have 1 hour of EPL, and yes, they would be able to use it if they've been employed for you for over 120 days. Additional things to keep in mind for employers, the Families First Coronavirus Response Act. In the most recent bill by set forth in Washington, and I can't recall the full name of it because they've been amending these so quickly. It extends the Families First Coronavirus Response Act ability to take leave until March 31st of 2021. And you don't, as an employer, have to permit employees to take leave, but if you do, you're going to be able to obtain the same tax benefits that were set forth previously in order to take the tax credit on a one-to-one ratio of all the money that you paid out under the Families First Coronavirus Response Act. Additionally, the Portland Minimum Wage Ordinance for those who have employees and a work location in Portland. Right now, we are waiting for a decision from the Superior Court regarding the date in which the statute or the ordinance went into effect, whether or not it did go into effect in December of 2020, or if the effective date is January 1st of 2022.
I think we're on the next slide, by the way. Just one.
Oh, yeah, sorry.
Although I see a bunch of questions piling in about the paid leave law. So why don't we go through this list of additional developments and then.
Yeah, and then I'll go back to earned paid leave. So we know under the ordinance, it included the hazard pay requirement. And the question is whether or not that time and a half hazard pay requirement went into effect in December of 2020, or if it'll go into effect on January 1st of 2022. If you read the Portland Press Herald this morning, you know that the judge has indicated that a ruling can be expected shortly as to the effective date of that. Maine non-solicitation and non-compete laws, that went into effect in 2019, but in 2020, we saw some cases that analyzed how one should construe Section 599B regarding restrictive employment agreements. And there was multiple arguments that the statute itself should not apply to contracting, employment contracting services or organizations who provide contract workers to companies. The court in both of the cases said it applies to all employers and that there's no limitation regarding staffing agencies in any effect. And I'll turn it over to Rob for NLRB update real quick.
President Biden has wasted no time in following through on his promise to be this is going to be a union White House. He broke with a 70-year tradition of letting the incumbent general counsel of the National Labor Relations Boards serve out their term. Yesterday, within minutes or hours after taking office, he demanded the resignation of the current GC, Peter Robb, who's overseen some pretty significant shifts in board policy, sort of correcting, or depending on your point of view, correcting or just reversing things that the Obama board had done. And I think this is a pretty clear signal that the era of sort of a more pro-management leaning board is now over. And we're going to see, I think, a lot more organizing, a lot more pro-union decisions coming out of the board. So, if you're not unionized already, hold on. If you are unionized, well, you can expect a fairly union-friendly board. And Tawny, there were a couple of questions about the paid leave law.
Yeah.
If we have, it's 10:30.
And so people, if you'd like to stay, I've answered some of them and have sent responses. A question, if we've already allotted our employees 40 hours of sick time every January 1st, is that sufficient to meet the Maine earned paid leave? The answer is maybe. There are a number of other standards that must be met concerning how it's used, that you can't require it to be used for certain situations when the employer's operations are closed, notice provisions regarding the taking of the leave. So potentially, but you would want to confirm based off of review of Maine's Department of Labor earned paid leave. Frequently asked questions, I guess, would be the best. So comparing your current policies to those that are required under the earned paid leave statute.
Yeah, and we found that the Maine DOL has been pretty responsive to answering our questions. So if you don't feel comfortable revealing who you are with your particular question, then routing them through your lawyer is not necessarily a bad idea. If you think that you want to do something different than what you predict the Maine DOL would say you have to do.
And then the final question, are you required to allow employees to carry over 40 hours of paid leave? If you front load earned paid leave, then you don't have an obligation to roll it over. So if on January 1st or the beginning of whatever year period you choose, you front load it and you give employees all 40 hours at the beginning, you don't have to roll it over. But otherwise, you would need to permit the carryover of the unused time if they choose to make that choice. If your employees choose to roll it over. You could choose to pay it out. So yes, payout is possible. If your policy you could have policy language that provides that instead of rolling EPL, employees could choose to have it paid out at the end of the year. So 12/31 if you use a calendar year.
Probably a good note to wrap up on. Thank you for your attention and great questions. I want to say that we'll be resuming in about half an hour or 25 minutes for the Massachusetts session. If you are one of those people who is signed up for both, we will be repeating some of this, in particular the vaccine discussion. And if you don't want to sit through the vaccine discussion again, I think I observed took us about 20-25 minutes to get through that for this session. There are a couple comments, however, that do relate specifically to Massachusetts and vaccines, so that might be of interest to you, but the slides should cover that as well. But we certainly appreciate you sticking around for the next session. But otherwise, thanks so much. And if you want to check out our website, our blog, please do to stay up to date. And we hope that you join us again a month from now for the next installment of our annual update, spread out over several months. So thanks. And Tawny, do you have anything else to say?
Nothing else to note right now. I'll see many of you back in half an hour for the Massachusetts update. But otherwise, thank you, everyone. I wish I could see all your faces, but I wish you all well and good health.